Before we start, it was pointed out that Human Rights Watch has recently circulated several reports in which they are strongly taking the position in favor of including the crime of aggression in the statute and also having a minimal role for the Security Council. But that clarification is important because it was suggested by some audience members that the NGOs were not, in fact, playing an aggressive role, and at least one, Human Rights Watch, led by Richard Dicker on this issue, has been. Okay, with that clarification, let's start the next panel. Our moderator for this panel is Mark Ellis. And Mark, together with Bill Shabus and myself, were the co-chairs that put together this. And I have known Mark for 20 years. Usually I see him in strange places like Dubai or Cairo, all over the world, because he is the executive director of the International Bar Association. And what he has brought to that association in particular has been a new focus on war crimes issues and on international criminal law issues. He's a real expert in the field, having published many things and recently gotten a PhD on the subject, and he is the moderator and will be introducing our panelists for this very exciting next panel.
Michael, thank you very much. It's great to be here. And I will have to say, when Michael first called me and asked me to participate in this particular conference, I was somewhat reluctant because I think I'm perhaps in the minority that I have never been a strong proponent of the inclusion of the crime of aggression into the statute. And it's not for the reasons that were described or discussed this afternoon. It's primarily because of my concern that because of the complexity of this crime, it would somehow dilute the focus on the core crimes of genocide, crimes against humanity, and war crimes. And that I've always been concerned that we've not solidified that type of support for those crimes yet within the international community, and I felt that perhaps we should continue to focus on gaining that type of support. It's a similar, in my opinion, about the general or generic approach of victims in front of the ICC, again, the concern that it takes away from the core goals and responsibilities. But having said that, I represent the International Bar Association, as Michael has said, and I have been a strong advocate within the IBA to come out with a definitive statement of support for the crime of aggression to be included, not to be included, but now to be implemented. And I believe that the council hopefully will not only debate this issue, but will approve this issue. And this is a council of 198 bar associations from throughout the world. So I'm cautiously optimistic that we will do that. But that's my caveat to start this. I thought what I would do before I turned it over to our two panelists is just to frame the issue, and the ambassador started that process in this superb talk he gave us at lunch, and to suggest that looking at some of these issues in the sense of the trigger mechanisms that hopefully we can discuss. And of course the definitional issues that we were discussing this morning are interrelated with the jurisdictional conditions, depending on what the definition will ultimately come out, will I think have, or some could impose a threshold on or threshold requirement on the jurisdictional part of this. And the main debate in these negotiations, as indicated by the ambassador, is really who will have the right to determine whether an act of aggression has been committed, and will it be done inside the court or outside the court. We've talked a lot about the Article 13 and whether or not these mechanisms that are under Article 13 are sufficient to be applied to the crime of aggression. I think Ben's remarks this morning was absolutely they are, that they are clearly there. There doesn't need to be much more discussion on that. Many states also believe that. But there are other states, as I think again alluded by the ambassador, who believe that the applicable or to be applicable to the crime of aggression in the sense from the Security Council, that it is a very special crime, and that the thought that it should be the exclusive should be the exclusive authority of the Security Council to make that determination. Of course, that would be the ultimate filter, because this whole issue of the relationship between the Security Council and the court is the most perplexing and I think challenging of issues. And as the ambassador suggested today, well, actually that involves more of a political discussion and debate, and I agree with him on that as well. So taking into account of Article 5, subsection 2, that the crime of aggression must be determined in accordance with the relevant provisions of the Charter of the UN, and this would raise the issue of whether the ICC depends on, again, this prior finding of the Security Council of an act of aggression. David has written in the past about the Security Council must act before an alleged crime of aggression can be prosecuted against an individual by the ICC, again, perhaps emphasizing the important role that the Security Council plays on this. The argument, of course, is already discussed this morning about Article 39, where under the Charter, where the Security Council would have exclusive competence to determine a state of active aggression. And again, David in his paper, and I think he'll allude to this today, says that, argues that Article 39 gives this, quote, clear, perhaps sole authority for the Security Council to decide on aggression, and that it's probably unacceptable to think that a situation where the ICC could move forward without deference to the Council's overall authority with respect to the threats of peace. But of course, that is countered by the argument that the Security Council would not have primary, would have primary but not exclusive authority to determine an act of aggression. And so where I'd like to go today is if we take into this discussion that the court could proceed in exercising the jurisdiction without or with the prior determination of the Security Council, where does that really leave us? And one last point, and this is again something the ambassador had indicated today, was the Security Council and whether or not it does in fact have the authority to trigger the court. Is it permissible to allow the 5 permanent members the exclusivity to make this determination? And of course, that's a huge issue. And then the last point is whether or not, and it was again alluded to, whether or not there are other authorities, other players that should play the role, either the General Assembly or the ICJ, and we can talk about that as well. I want to ask Elizabeth to start off this conversation, discussion. Elizabeth Welbshurst is the Associate Fellow, Welbshurst is Associate Fellow of International Law at the Chatham House, and is a visiting professor at the University of College in London. She was a legal advisor in the United Kingdom Diplomatic Service between 1974 and 2003. And of course, for those of us who live in London, she was well known as an individual who decided that she could no longer continue in her position and resign because of her belief that the war in Iraq was illegal, and this brought a great deal of support for her and a tremendous degree of respect within the legal community and certainly with the International Bar Association. So Elizabeth, I'll hand this over to you.
Thank you for your generous introduction, Mark. Chatham House, incidentally, it's the home of the Chatham House Rule.
Oh, sorry, yes.
No matter. I want to step back before we begin to look at the technicalities of trigger mechanisms and Security Council role. Why do we need to consider jurisdictional issues in relation to aggression at all? Of course, it's there in Article 5.2, but are there more legitimate reasons than that the P5 and possibly a few other states want to protect themselves by means of their Security Council veto from having their leaders criminalised? I'll be following really directly on from many of the remarks made this morning in different panels. I hope I won't be repeating what's been said, but I think a lot of these difficult issues in relation to the crime of aggression justify our considering very carefully the jurisdictional issues of when will aggression be prosecuted. I've just got 4 points here before I consider their relevance for the jurisdictional issues. The first point relates to the diverse interpretations of international law and the use of force. We had that this morning, or at least these difficulties were touched on. We had a reference to humanitarian intervention. The proposal that there should be a waiver provision for this, I think, was, I'm afraid, put to bed by Ambassador Ferencz by saying that really the draft that we have before us on the elements of the crimes, the substantive part of the crime, is the only game in town. Sean Murphy was happy, as it were, to advise his government that they could go into acceptance of a definition of the crime of aggression, knowing that humanitarian was criminal, but being able to rely on a prosecutor not bringing an indictment. I'm not sure that many governments would be happy with that. But the fact is that humanitarian intervention, I rather agree with Sean Murphy, that it is at the moment criminalised by the draft definition. Another area of the rules of international law and use of force, self-defence. Again, we touched on that, but there are two major areas of self-defence on which it seems to be impossible to get global agreement. One of those is anticipatory self-defence. That's the legal part of anticipatory self-defence, relying on the Caroline case, the doctrines of imminence, necessity and proportionality. Most lawyers, I think, in this country and in the UK, would agree that that's lawful, but you have the International Court of Justice, at least on one view of the Nicaragua case, saying that that might not be lawful. And similarly in the DRC in Uganda, the ICJ stated it was unnecessary to express a view on the question, not being brave enough to say whether anticipatory self-defence is lawful. You have preemptive self-defence, the so-called Bush Doctrine, that's generally considered to be unlawful. Even with regard to anticipatory self-defence, you have the 2003 World Summit outcome not mentioning the question of anticipatory self-defence, although the UN High-Level Panel's report, A More Secure World, and the Secretary-General's report, In Larger Freedom, invited approbation of his view that the right of self-defence existed in the case of imminent attack. Now, the difficulty for the ICC will be that governments in this respect, in the case of self-defence, are acting on specific views of the law which differ from one another. The second controversial point on self-defence relates to whether it's lawful for force to be used in response to attacks by non-state actors operating from another state. We have state practice following 9/11, including the declared views of NATO, OAS and other states, including Security Council resolutions, quite clearly supporting the view that a state intervening against terrorists in another state in self-defence are justified, legally justified. On the other hand, you have the ICJ's pronouncement in the Wall advisory opinion and its statement in the DRC and Uganda, which are used to support counter-arguments that there's no such right. And an example of the difference of view was in the recent Colombia-Ecuador dispute over Colombia's incursion into Ecuador and their targeting of FARC rebels, where the OAC restated the principle of sovereignty, which couldn't be infringed by other states on any grounds whatsoever. And John Negroponte said that the US supported the resolution in general, but argued that Colombia's military incursion was justifiable on the basis of legitimate defense. Why am I going back to these elements of the crime of aggression when I'm talking about jurisdiction? It's simply clear that many modern-day military interventions are given different legal analyses in different parts of the world. And the absence of shared standards, which will continue even after a definition of aggression is accepted, means that it'll be very difficult for the ICC to have to deal with these controversies. Of course, one response may be that it's precisely because of the difficulties in applying the law on the use of force that it's desirable to have a universal court which can make such determinations. But the International Court of Justice, which has far greater experience of such matters, and, dare I say it, more qualified international lawyers on its bench, hasn't succeeded in solving, to the satisfaction of many, these fundamental difficulties and differences between states on the law on the use of force. Is the ICC more competent than the ICJ to deal with these matters, particularly at this stage when it's still in its infancy? And that brings me to the second consideration, which is the current position of the court. The ICC, as we've heard this morning, is in the middle of controversy. The prosecutor's application for an arrest warrant for President Bashir is acutely controversial, at least so far as the crime of genocide is concerned, and obviously more generally. And the situation has highlighted the difficulties of a court which has to rely on the world community if it's to be effective. It's clear that the international community is not solidly behind the court at the moment. African states are threatening to withdraw from the statute, and the court is being portrayed by members of the African Union and the Arab League, as we heard this morning, as a Western tool. Without international support, the court becomes no more than a legal fiction. The problem is, in allowing the ICC to prosecute for aggression without full-scale international support, is there a risk that the effective operation of the new court will be prejudiced? The court is struggling at the moment with pre-trial procedures for its more normal cases. Again, the prosecutor is being criticised for his handling of evidence in the Lubanga case. Third quick point, very briefly, the relationship with peace and security. Some commentators consider that investigations of aggression undertaken by the ICC, far from assisting with the maintenance of international peace and security, might bring about an escalation of a situation. Claims that investigations by the ICC are already causing damage to attempts to bring peace are many. The arrest warrants against Kony and other leaders of the LRA, the warrant against Bemba, above all, the application for the arrest warrant for President Bashir, all from one court or another, have been alleged to have had a detrimental impact on peace and security. I'm not going to assess these claims. Indeed, I don't think it's really for lawyers to do so. And I think a lot of the claims of detriment have to be taken with a very large pinch of salt. But the tension between peace and justice is acute. And we have to recognise the even greater impact of prosecutions for aggression. And fourthly, the position of non-party states. Opposition to the assertion of jurisdiction by the ICC over the nationals of non-party states will undoubtedly be increased if the ICC exercises its power to decide whether the leaders of such states have committed aggression. While the court will be able to try aggression only in respect of states parties which have accepted a statute amendment incorporating a definition, this opt-in system for jurisdiction over aggression has not been provided for states which are not parties. So that's just a fourth consideration, which we have to bear all these in mind in considering what the jurisdictional conditions should be. I think we have to recognise that the International Criminal Justice Project is at a bit of a vulnerable stage at the moment. We had reference to Article 16 negotiations this morning, and more generally, I note with concern that commentators are beginning to ask whether the world is ready for a permanent international court at all. I doubt that the climate will have changed significantly by the time of the review conference. These considerations shouldn't lead to doubts about the inclusion of aggression in the ICC statute, but they should make us consider what should be the jurisdictional considerations, conditions for the prosecution of aggression. So my very few words on jurisdictional issues are subject to those considerations. In my view, it's by now clear that a requirement for a Security Council determination of aggression by a state is not necessitated by the UN Charter. It's clear that the General Assembly has also the power to consider aggression. It's obvious that the International Court of Justice can do the same. So there's no legal requirement that the council has to be involved. But provision for council involvement would be compatible with the Charter, and of course it would serve the goal of ensuring that the international community supports the court in investigating a case of aggression. But as we've had this told us this morning, there are of course serious disadvantages in providing for council involvement. They're largely political. A part of the world has come to regard the court as a Western one, and this misconception has been encouraged by the fact that the only cases being tried are in developing countries, indeed in Africa. Although you can answer this criticism by reference to the nature of the court, that it's complementary to national systems, the arguments, the conception still exists. There is also, as was mentioned by the ambassador, the fact that many states give as their reason for not joining the court the fact that aggression wasn't included within the effective jurisdiction. That's, for example, the Arab group. And it won't be of assistance to them to have aggression added with a Security Council filter. So what to do? The involvement of the Security Council would indicate that the international community was prepared to accept that the court was in the right state to investigate aggression, and that the particular case would not damage international peace and security. But similarly, the involvement of the Security Council would cause these other problems, and the retention of the veto is one of the most obvious. The question was put to me, why do we need to examine the difficult question of jurisdictional conditions and the role of the Security Council if we take the amendment procedure of the ICC statute at its face value and accept that jurisdiction over aggression is subject to an opt-in by the state concerned? You'll see that in Article 121.5, although I know there is some interpretation to the contrary. But in my view, that provision makes clear that the addition of effective jurisdiction over aggression will only be applicable with regard to states parties which have accepted that jurisdiction, and with regard to their nationals, and with regard to actions on their territories. If, but only if, this provision were extended by the review conference to the nationals of non-states parties, would there be any need for Security Council involvement at all, since any party concerned would have accepted the jurisdiction of the court in advance? Now, this suggestion has the attraction of addressing many of the problems I've outlined. If the provision were to be extended to non-state parties as well, each state could decide for itself when it regarded the court as being sufficiently bedded in to enable it to deal with the question of aggression, bedded in both as to procedures and practice. That might not happen for many years. It would depend on the development both of the court and of the attitude of the international community to the court, and perhaps upon greater consensus being reached on the rules of international law. Certainly, in my view, it would require a change of legal culture. As Ben Ferencz said this morning, the temple of law is built one stone at a time, and I think we should not be worried if we do not get to the end of the race before we have sufficiently begun it.
Elizabeth, thank you very much. Our next speaker is Ambassador David Scheffer, who is Professor of Law at Northwestern University. He's also the Director of the Center for International Human Rights at the university. As many of you know, he was the Ambassador at Large for War Crimes from 1997 and 2001, and also, of course, led the U.S. delegation in the UN talks establishing the International Criminal Court. For all of us who have worked with David over the years, he's known as really one of the most preeminent experts in this field, and has really been a leader in this area. So David, delighted to have you here.
Thank you very much, Mark, and it's a great honor to be with Elizabeth again. Before I shoot up the PowerPoint, let me just make a few introductory remarks. First, thanks to Professor Cherif Director Scharf, Maestro Scharf for this entire event, as well as Mark and Bill Shabus, who I know have been in the leadership of it, and all of my friends and colleagues that I see in the audience who are too numerous to start going down the roster, but I am deeply grateful that you're all here. I just wanted to, I'm sorry about this. It's very awkward, but I'm a little compelled to have to put a qualifier to my remarks today. I happen to be working with the Obama campaign on the foreign policy team, and it's very important for me to say to you that everything that I say here today is strictly, solely, exclusively, and only my personal reflections, comments, views, recorded remarks, have nothing to do whatsoever with the campaign or with Senator Obama or anyone working with him. This is just me today. So with that out of the way, I'd like to show you a couple of PowerPoints as I speak today, because what I'd like to do is put forward to you a couple of options to consider. I know that Ambassador Van Vesa and Stefan, his colleague, and the team of negotiators in the working group have made great progress, as well as they're stuck in some places, and their expertise far overwhelms mine on this subject, and I don't want to presume that anything I suggest today actually preempts or is in any sense going to surpass the work that they're doing, which is very, very difficult work. But I do think it might be interesting for you to see some ideas which might trigger some thinking and some ways to deal with a problem that I have struggled with, which is certainly since leaving the Clinton administration at the end of the Clinton administration, and the U.S. seat has been empty since then, we left our position on the crime of aggression in a particular place in January 2001. And I don't want you to presume that when speaking today, I am literally left speaking only as if I sat before you in January 2001. I'm sitting in front of you in September 2008. A lot has happened since then. And so what I want to do is to provide a few additional forward-leaning perspectives on this issue that are not associated with what was the Clinton administration. And certainly there's been nothing of this discussed with respect to the future, but it is some of my own thinking and will be in an article which is being published in the Symposium edition. So I'm going to stand at this point and work the PowerPoint, if I can do it efficiently enough and without having all sorts of mishaps. I understand I hit escape, and I'm going to need a little help since I don't know where my PowerPoints are once I hit that escape button here. Do I hit it again? Sorry about that. There you go. Okay, and then just page up, down. Right, okay. This, okay. There's a lot here that actually I prepared for Professor Shabus's ICC course last June, so just forget about that. Okay. I'm going to offer you two options of how to look at this issue afresh. And the working group has already had exposure to these ideas. I think most, if not all, of the working group has moved beyond these ideas now, but I'd like to return to them because, frankly, I think they still have currency given the state of play that is in front of the working group still in September of 2008. First, I want to say that in the negotiations up through January of 2001, we always had this dilemma in the negotiating room of how to address the totality of what was being proposed. And I always presented the point of view in these negotiations that, in fact, if we're going to establish a rule regarding the crime of aggression, we also have to look at the exceptions to the rule, and we have to somehow factor in protection of nationals, humanitarian intervention, and all of those, counterterrorism, all of those issues that we've spoken so much about today simply cannot be taken off the table. Now, in an effort to achieve a compromise within the special working group, I humbly submit these two options. The two options enable negotiators to consider a range of opportunities by which to argue the merits of sustaining some form of UN Security Council arrangement in the trigger mechanism, and yet to do so within a singular approach to the personal jurisdiction and subject matter jurisdiction requirements of the crime of aggression. Option 1, which we'll start with, is the more unorthodox but arguably realistic proposal, while option 2 remains within a more conventional yet dynamic mode of decision making. And I do this all as if I were amending Article 10 of the Rome Statute and simply adding the crime of aggression to Article 10 after the existing Article 10 text. Option 1 steers the trigger mechanism away from political determinations of aggression per se and towards a more pragmatic methodology in terms of how the UN Security Council actually operates. The new Article 10.2 of Article 1 would provide two triggers for ICC jurisdiction over the crime of aggression. The first trigger would require that, quote, the Security Council has determined that an act of aggression has been attempted or committed by one state, the conventional formulation. This reflects the long-standing proposal of the permanent Security Council members and other nations that would minimize any concerns about contravening the UN Charter because the Security Council has clear and some would argue sole authority to make such a determination pursuant to Article 39 of the Charter. Once such a determination on aggression is made by the Council, then the ICC prosecutor could investigate any individual who might be responsible. We've talked a lot about this in the conventional P5 proposal of Security Council referrals. Now, my proposal simply positions this as the first of two alternative means to trigger ICC jurisdiction. The reality, however, is that the Security Council rarely makes such an emphatic decision on an act of aggression. The question governments must face up to is whether there should be a continued role for the Security Council in the trigger mechanism in the absence of an explicit decision by the Council on aggression, and whether that role should reflect the reality of how the Council actually operates. If the trigger mechanism requires a continued role for the Security Council, an outcome that may be necessary in order to achieve a broad consensus on the crime of aggression for the Rome Statute, then new Article 10.2 of Option 1 provides that when the Security Council makes a determination about the existence of any threat to the peace or breach of the peace, which it is empowered to make but which may or may not describe an actual act of aggression, then an international court of law has the opportunity to determine, if the first part of this option is not chosen by the Council, an opportunity to determine whether an act of aggression in fact has occurred. So on the one hand, you can make the political decision through the Security Council, or you can default to an international court decision on the issue. The proposed language narrows the nature of the threat to or breach of the peace to those situations which are the result of the threat or use of armed force by one state against another state. And I think this is consistent with where the working group is going. I've structured the proposal in this vein in order to achieve common ground on the character of state-to-state aggression or state-on-state aggression that all governments can agree would constitute the context within which an individual should be subject to an investigation and, if merited, prosecution. Now, absent from a determination by the Security Council on issues of armed force, the formulation I'm putting up here does omit economic aggression, political aggression, and other alleged forms of aggression that occur without the use of armed force. One can always make those arguments. In fact, the Council itself can move in that direction if it wishes to in a resolution, but it will not kick it into ICC prosecution. It will only be armed force character aggression that actually gives rise to criminal prosecution before this particular court. Now, I've bracketed two sub-options pursuant to which a judicial body would make the determination of state-on-state aggression in the event the Security Council does not explicitly do so, as described in the option. The first sub-option would designate the ICC as the judicial body, empowered to make a judgment. Some may find this option too problematic and risky because the ICC judge's primary expertise likely will be in national or international criminal law and not the international law jurisprudence and theory typically associated with judgments about state-on-state acts of aggression. The latter kind of expertise would be found in the second sub-option, whereby the International Court of Justice either one, would deliver a judgment on aggression pursuant to a contentious case between states, or two, would follow the procedure of acting upon a formal request by the Security Council or the UN General Assembly to deliver an advisory opinion on whether an act of aggression has been attempted or committed. Advisory opinions often can be delivered within a relatively short period of time compared to judgments in contentious cases. In fact, of the 24 ICJ advisory opinions since 1947, 62.5%, 14 of them, were rendered within 8 months of their respective filings. And such a procedure might lend itself to the need to act in a timely manner to deter alleged aggressors from continuing with plans or actions relating to aggression. Now, there are other parts of option one that relate to the definition of aggression. I'm not going to focus on that here. We can always go back to that if you wish to. The Security Council rarely resorts to aggression terminology, and the examples of the now distant past demonstrate that the Council has used the term to describe relatively minor uses of military force while using other UN Charter terminology such as threats to or breaches of the international peace and security, unlawful use of force, etc., to describe far more significant uses of military force classically regarded as aggression. Once the Security Council determines that a threat to or breach of the peace has occurred, often by condemning it, that determination memorialized in a resolution should be sufficient to trigger a process that can determine whether an act of state-on-state aggression per se has occurred, which then would enable the ICC to investigate persons for purposes of individual criminal responsibility. Now, permanent members of the Security Council, concerned that this methodology too easily would open the door to determinations of state-on-state aggression, which arguably only the Security Council should make pursuant to Article 39, could remain confident that any determination or condemnation regarding a threat to or breach of the peace as a result of the threat or use of armed force, which is adopted by the Council in a resolution, likely will not condemn any one of them. Of course, such a result understandably will be of concern to other governments, resentful of the powers and protection that the permanent members enjoy under the UN Charter. But the advantage of the proposal is that it realistically would open up most, perhaps all, if the P5 actually refrained from aggression, situations of aggression in the future to scrutiny by the ICC if the Security Council or, depending on which bracketed option is chosen, the ICC or the ICJ reaches the preliminary decision that state-on-state aggression has occurred following a determination by the Security Council that a threat to or breach of the peace has occurred. Now, there has been commentary within the working group, special working group, with respect to this approach, namely that, quote, a council decision might be interpreted as de facto determination of an act of aggression irrespective of the council's intention. It might therefore have a negative impact on the decision-making within the council, which might adjust the way it used certain terms. It was argued in the special working group that this option would also create a subordinate relationship between the court and the council. Now, there's a lot to rebut in that statement, and if I get into it, I'll never finish. So I'm going to actually spare you my long rebuttal to that statement. But I just want you to know that if we want to get into that, I think there's a lot of responses to it. I want to move on, if I can, to option number 2, which is right here. Now, option 2 preserves a significant role for the Security Council, but at the discretion of the Council offers the option of sharing the final determination of whether aggression has occurred with certain other designated UN organs or the ICC itself. It recognizes that the Security Council may not, indeed probably will not, want to make an immediate determination about aggression, but may be willing to trigger a process that enables another UN organ or the ICC to make that call. It is passing the buck to other bodies, but in a way that remains within the initial control of the Security Council. Under option 2, the wording of which is set forth here, propose a formula which upholds Security Council authority in all determinations regarding the trigger mechanism for ICC investigation of the crime of aggression, but enables the Council at its discretion essentially to delegate the determination of state-on-state aggression to the General Assembly or the ICJ or the ICC to await a further resolution of the Security Council, or a further resolution of the Security Council itself, in fact. But the Security Council steers the decision-making process into the institution of its choosing if the Council has chosen not to make the decision itself. And I was certainly inspired, from sitting in on the working group discussions, which are just so dominant with this point of, well, what if there is no decision made? What's the default if there's no decision? Now, this new option is used as the relatively empty vessel in which to establish the jurisdictional and definitional requirements of the crime of aggression. It creates the trigger mechanism as a choice among three possible determinations. It retains the conventional procedure of a Security Council determination, but then it also kicks it into the approaches that you see up there, which is one option would be to the ICC itself, and the second approach would be set forth. The Council must explicitly require in its referral resolution that there be a decision of the ICC that an act of aggression has been attempted or committed by one state against another state. I think I've mixed this up a little bit. In the first approach, before an investigation can be initiated by the prosecutor, pursuant to Article 53, the ICC must await a subsequent determination regarding whether an act of aggression has been attempted or committed by one state or another state, either by the General Assembly, the Security Council, or the ICJ. And then, of course, the second option would be the ICC. You could actually fold that all into four if you wanted to, as opposed to having one or the other. My hope is that negotiators will recognize the considerable latitude afforded the Security Council in these proposals, such that a far broader range of situations which may constitute state-on-state aggression, in fact, can be brought before the ICC for investigation of individual criminal responsibility. This bridge between those governments which believe in a central role for the Security Council and those governments which reject that view is intended to establish a very pragmatic but disciplined process. I purposely do not include within any definitional structure acts of strictly internal aggression or terrorist or militia acts unconnected to state authority. That is a bridge too far for customary international law and for the ICC's criminal jurisdiction at this stage, in my view. I also think moving in that direction would break the back of the entire exercise. Now, I'll just conclude with this. For purposes of the trigger mechanism for ICC jurisdiction over the crime of aggression, how the Security Council, General Assembly, ICJ, or ICC arrive at a determination that state-on-state aggression has occurred in either option 1 or 2 would be a process that could look to UNGA Resolution 3314 of 1974 for guidance and to other principles of customary international law. 3314 in Articles 1, 2, and 3 is focused on the use of armed force. So we can still look to that as guidance, and a lot of governments want to look to that for guidance. I don't think we need to take that off the table. We can put it back on the table as long as there are some predicates to it. But for the purpose of individual criminal culpability determined by the ICC, I propose a singular definition that I haven't described here that narrows the exercise to a leadership role in the unlawful military intervention by one state against another state of such gravity and duration as to constitute a grave violation of the prohibition on the use of force under Article 2.4 of the UN Charter. And I think I will leave it there. I know I'm racing, and I've raced through a lot, but I'll try to keep this short. Thanks. Mark.
Thank you very much. This opens up a good deal of time for some questions. I wanted, as the chair, just to pose one question to each. And Elizabeth, if I might ask you, Cherif today in his very compelling address said something that I wrote down, and correct me, Cherif, if I mistake this, but he said he questioned whether criminalizing aggression would ever deter a future head of state from committing it. And looking at the preamble and the whole basis of the ICC as a way to end impunity and to contribute to the prevention of such crimes, is there a contradiction in the sense of bringing the crime of aggression in when we're essentially admitting that we're really never going to be able to deter that crime?
I rather agree with Cherif, but I think deterrence is only one of the purposes, isn't it, of international criminal justice, and bringing a sense of justice to people is another. Yeah.
I would agree with Elizabeth on that. You know, this is a question that all of us in this discipline are posed with just about every single day. Please discuss the deterrence argument. And there does come a point where you can draw a line that, yes, there is a potential in the work of the International Criminal Tribunals, and particularly the ICC, of long-term, long-range deterrence. We may have to wait 20, 30, 40 years for it to sink in. And I think if we look at the example of Japan and Germany after World War II, I think what happened at the Nuremberg and Tokyo tribunals has had an impact, not on the immediate generations, but on subsequent generations in those countries. So I would always argue in favor of looking at deterrence in a long-term view, but then I would go back to what Elizabeth mentioned, which is when it comes down to it, frankly, we are looking at retribution here. This is retribution. This is an exercise in retribution. And if you talk to the victims, largely that is what they want. And then if they can get some compensation or reparations, if that's pragmatically possible, or recognition of their plight, then they want that, or an apology. But they want retribution, and that, of course, is what a court of law offers. I might just add that it's interesting how some of the Lord's Resistance Army leaders who have defected in Uganda have actually noted that the ICC is brought up about 5 times a day in the camps, that they talk about it incessantly. And I think you find Coney now spending more time trying to strategize evasion from arrest than he does committing well-planned systematic atrocities.
And one last point, question, and this gets something actually the ambassador had said over lunch, not in his talk, and he spoke about a middle ground and this green light approach where the court could proceed with the case if the Security Council gave its consent, but without making a specific determination that an act of aggression had been committed. What's your sense on that approach?
Elizabeth? Start?
No, after you.
Okay. Well, I think the green light does have some merit to it. It's still going to be a difficult decision-making process within the council whether or not to unleash the ICC with that sort of specific mandate. But frankly, it's no more difficult than the proposal that I just put on the table, where the council knows that there is a prospective action out there that they can trigger if they wish to, in terms of making a determination and then kicking over to a judicial body the actual legal determination as to whether or not aggression has occurred. I think both the green light and my own proposal, unless I'm misunderstanding the green light, do go to the issue of placing at least some responsibility on the council to get serious, as opposed to just acquiescing or being silent, and by virtue of silence, letting the matter fester and not taking a position on it. So there is sort of an upgrade in responsibility building, I think, in both proposals.
Okay.
Yeah.
Sorry, Elizabeth, go ahead.
I was going to respond. I think the main issue really is whether you are going to accept that the Security Council is a sine qua non before ICC proceedings. If you're going to accept that, then you can talk about the way in which the council has an involvement, whether one of David's proposals, whether just to provide a green light, whether to actually make a determination. I don't know whether that first question has yet been answered, whether the council has to have an involvement.
And of course, I took the step in my proposal, of course, of assuming that if you are going to have Security Council involvement, how do we structure it? There are many arguments that the group works with whereby the Security Council is an option, one among many, and that can fall off as an option fairly quickly depending on the circumstances.
Go right down the row here, and then I'll shift over. We'll put the one up, and then down.
Question for Professor Sheffer. How would you imagine a role for the Security Council that does not violate certain principles of legality that some of the working group members are concerned about? And also, beyond the principle of legality, having the crime only defined after the aggression determination has been made by the council, the rights of to challenge the charges, every aspect of the charges, and also the presumption of innocence.
Well, your question really focuses on the conventional referral by the Security Council of a matter or a determination that an act of aggression has occurred, and that then triggers the court's jurisdiction, the ICC's jurisdiction. I think your question is really when you're talking about legality, you're focusing on that, correct?
But also within, as an element of the crime, having a state act determined.
Yes,
by the
yeah.
council is my concern.
Yeah. No, and that's been with that concern of legality, as you know, has been with us for, gosh, what now, 15 years or so in the debate on all of this. And I think the way I approach it is, I don't think you can approach the crime of aggression. This is distinguished from what the ICJ does, which is it looks at state-on-state aggression, not in a criminal law context, but in an international law context. And I see that as a separate exercise of establishing whether or not aggression has occurred before a court of law. And for example, my proposal actually offers you a political route to aggression. It offers you a legal route to aggression. So your question of legality is very appropriate. What if you take the political route to aggression? And instead of the ICJ determining that aggression has occurred and then the ICC stepping in for criminal responsibility, the Security Council determines that aggression has occurred, and then the ICC steps in for criminal responsibility. First, I would think that the prosecutor, in presenting any application for an arrest warrant, is going to have an incredible burden of demonstrating to the court that the court can in fact take this case, take this individual, and under the elements of crimes that are developed for the crime of aggression, that the prosecutor is able to prove that he can substantiate what the Security Council itself has determined on a political basis. He can substantiate in a court of law that the particular individual has committed the crime of aggression. Now, I don't think I would impose upon him the burden of proving that the state as a state organ has committed aggression, because that is a political decision that's already been made. And that's where the issue of legality is hanging, and it has been for 15 years.
Oh, right. I'd love to get an opportunity perhaps to ask a different question to each panelist, but just if I can follow up from what my colleague has said, I should say, Robbie Manson from Wales. If I can follow up from the point that was made there, could I ask Ambassador Sheffer to begin with anyway? I noticed what you said in your presentation with regard to your view as to the capacity of the ICJ in the exercise of its advisory jurisdiction to be able to make a determination with regard to an act of an aggression. And the advisory jurisdiction naturally, of course, presupposes that there has been an invitation by a relevant political body, whether it's the General Assembly or the Security Council.
And that's part of the proposal, yeah.
Yeah. I'm not so clear, though, on this point, and that's your view as to the current constitutional situation under the Charter of the United Nations with regard to its, as I would say, its ordinary contentious jurisdiction? Do you take the view that within that jurisdiction, that court, the ICJ, may or may not determine the existence, I know it never has, but I mean, theoretically I'm speaking here, may or may not determine the existence of an act of an aggression? And if it is your view that it could constitutionally do so, even absent prior determination by a political body like the Security Council, why do you say that the ICC should be in such a different position to the ICJ, if you follow my...
Oh, I think I do. Well, I think I answered that partly already, which is it is a determination as to whether or not we have enough confidence in the ICC to make that particular type of legal judgment. I mean, we do have experience now, both, well, certainly with the International Court of Justice, whereby we know that their expertise in international law does focus on state-to-state use of force or state-on-state use of force, and ergo issues of aggression arise within that context. We haven't introduced that notion of determining state liability, essentially, to criminal law judges. Now, we could make the leap and do that, and my proposal suggests, if you want the option, go to the ICC, if that's the judgment of the working group and ultimately of the state's parties. Go to the ICC. Go to the judges. Have them make that determination. I'm only saying that you're going to, that's a huge leap. And if governments want to make that leap and give that power to criminal judges to look at state responsibility issues, then, you know, I'm not standing in the way of that. I'm just saying that's a much larger leap than going to the ICJ for that determination.
Just so that I'm clear, your concern is not as a matter of constitutional principle. Your concern is essentially about whether or not, under the existing regime, there is the professional expertise amongst the judges.
Well, precisely because constitutionally I have the Security Council initiating the process.
Well, yeah, but what I'm saying, if your concerns about the competence of ICC judges could be assuaged by a different, then you would no longer require the Security Council to be the only exclusive predetermination. That would deal with it.
Well, but within my proposal, they have to initiate the process. The Security Council does, you see. No, seriously. I mean, you can't just automatically have the ICC.
You're not going to move away from that position no matter who you put in charge of the ICC in the bench. It doesn't matter what judges really sit on the bench of the ICC.
Well, if it was my choice, I would not choose my part of the option that says ICC. I would choose the ICJ option, if it was my decision alone to make. I just am very cognizant of years of discussions going on among other governments.
I'd be curious about the views of either speaker about the politics, particularly in the developing world, on this issue, because you know, I came to age back when in law school and the Nicaragua case was going through the International Court, and one of the big lessons there was if you're a weaker state, you love the idea of a forum you can go to that will kind of level the playing field. So I would have thought that most countries in the world that don't have a capability of projecting transnational uses of force, most countries in the world aren't worried so much about them being indicted for a crime of aggression, although maybe some of them will do that. But they're more worried about being attacked by the powerful states. Mm-hmm. And so the whole idea of having the Security Council as the trigger is totally unattractive. Now, I understand that the advantage of the trigger is it might bring the powerful states in, but maybe you don't care about that, right? Because whether they're a party to the Rome Statute or not, if they actually invade your country and you are a party, right, if I'm understanding correctly the way it will work, it is possible to indict for that mm-hmm. act. Mm-hmm. So at the end of the day, is it a bad prediction that the jurisdictional process is going to be one that does not involve a sole trigger by the Security Council?
Well, a perfectly good point, Sean. And I would look to Christian, frankly, for the better answer on that. It's perfectly possible that a majority of states who would not, and as we've heard, I was certainly aware of this as a negotiator. If there's anything that's a certainty in international negotiations, it's that most countries hate the Security Council, period. Please don't raise it. And so that's a given. Now, the reality, however, is that in order to go forward in this process, you can go down one path and exclude the sole Security Council trigger mechanism. What I've tried to do is provide a modification to it so that you can get some decisions into a few other forums after the Security Council tips its hat in the most normal way, frankly, on threats to international peace and security. But it is certainly true, Sean, that you could have a process ultimately unfold whereby, yes, they will have the Security Council as an option. They will concede that. They will say the Security Council can trigger this process if it wishes to, with a resolution on aggression. But in the absence of that, we insist by majority vote on a completely alternative formulation. And that may happen. I'm just saying I'd like to put forward an alternative to that so that if it were to happen with the majority of states providing an alternative methodology to get the court triggered on this, I think it is of great concern to many of us how many existing states parties who might object to that procedure will actually simply opt out under 121.5.
I had skipped, for Sean, I had skipped Bill, so I apologize, Bill.
Well, this is a question, I guess, more about politics than about law as well. David, what you've just described, where the review conference might take a vote, and Ambassador Venevesor said that was possible, that was an option, it could come to a vote, his talk at lunchtime. Is it thinkable politically that the statute could be amended on this issue without the consent of the 5 permanent members of the Security Council, or some of them? Could that happen over the opposition of all 5 of them? I know it could mathematically, but could it happen politically?
Well, let me kick that to Elizabeth first. Yeah.
Thank you. Yes, I need to speak. The ICC statute was adopted over the opposition of the US and over the practical opposition of China as well. So I think it could. Yes, I think it could. But I very much agree with, probably it was Christian, whoever said this morning, that it really is most important that changes that are made to the ICC statute are made with the agreement of most of the international community. I don't know that the P5 is completely isolated on this. Maybe they are. They didn't used to be. And it may be that the P5 should be seriously creative in their thinking now, because I do think it would be bad for the court and it would be bad for the international community if what you've suggested did happen. But yes, it could happen.
Thank you. My name is Stefan Barriga. I'm with the mission of Lichtenstein, and I've also been assisting Ambassador Venevesor in the work of the Special Working Group. I have 2 comments on the previous points that were raised on legality and on the trigger. I actually think that on both of these issues, we are actually even further advanced in the discussions in the Special Working Group. When it comes to legality and the question, once the Security Council has made a determination of an act of aggression by one state or against another, is it binding on the ICC for the purpose of individual criminal jurisdiction? And I can quote paragraph 37 of the latest report of the Special Working Group, and we have discussed this in the past. It says, it's paragraph 40. It was recalled that the Special Working Group had in the past already agreed that any determination of aggression by an organ outside the court would not be binding for the purpose of individual criminal prosecution. In addition, it was suggested that this important consideration should be explicitly reflected in the text. Currently, that's not in the chairman's paper. However, if you would transpose the chairman's paper into the Rome statute, it would follow from the rest that it would not be binding because the prosecutor has to make the whole case and the defendant has to have the opportunity to refute all the elements of the crime. So I think we actually And I was very happily surprised when it happened in a working group. We have agreement on this issue that the court would not be bound by this determination. Second, on the trigger, again, I think we might be even a little bit further, namely even in the current chairman's paper, and that is Article 15 bis, paragraph 1, it says, the court may exercise jurisdiction over the crime of aggression in accordance with Article 13 of the statute, subject to the rest of that article. And that means that in principle, all three trigger mechanisms apply, that the crime of aggression can be referred to the ICC by a state party, by the Security Council, or by the prosecutor proprio motu, who would then start with a preliminary investigation. However, at a later stage, following the preliminary investigation, this is where then the different options begin, and those countries that want to have a strong Security Council involvement say, well, at that stage, you have to check whether the Security Council has made a substantive determination of aggression, which is why I think, actually, David, that your option 2 is actually already in the paper, and even if the option in the end would be adopted that goes the furthest towards what the permanent members of the Security Council want, that would be included, that possibility, that the Security Council could say, okay, prosecutor, look into the situation. Actually, the council does not have to specify what crime he's referring to when referring a situation. But before the prosecutor then goes to the investigation stage, the prosecutor would have to go back to the Security Council and see if there's a determination of aggression. And then the opinions divide. After a certain time, if the council does not act, what should happen? Should the prosecutor proceed? Should the ICJ get a shot? Should the General Assembly get a shot? Mm-hmm. So I think on these issues, we're actually even a little bit further. But of course, the crucial question remains, should substantive determination by the Security Council be required or not? Thank you.
That's very helpful, Stefan. And when I developed these thoughts, it was about a year ago, and I know you've made a lot of progress since then.
Ben?
My question is addressed to Ms. Wills first. Thank you for your reference to my observation that the law is developed one step at a time. It reminded me of the story of the American who was in England, London, and he stopped an English gentleman and said, "Can you tell me how long it takes me to walk to Buckingham Palace or to Parliament?" The man gave him no answer. He repeated the question. The English gentleman said nothing. The American got discouraged and brushed away. The Englishman shouted after him, 12 minutes. Came back and said, "Why did you sell nothing before?" He said, "I wanted to see how fast you walk." Well, one step at a time, it depends how fast you walk. I was a little concerned about your observation after you correctly pointed out many new problems which are included in all the things we have now, and probably many more which you or I could both think of. I was a little bit unhappy about your observation that the ICC, what you call the ICC project, you doubted if the world was ready for it. My question is, in the light of the increasing capacity of warfare and the communications revolution that's taking place, do you think we can still proceed at the past pace without jeopardizing the peace and security of the world?
Ben, I didn't think myself that the world is not ready for the International Criminal Court. I said that I had noted with some dismay that some commentators were now saying that at the moment because of the difficulties that the ICC is subject to. I wish that I shared your views that if we had aggression in the statute tomorrow with universal jurisdiction, it would deter the kind of military adventures that we've had in the last couple of decades, which both you and I wish hadn't happened and would not happen in the future. But I fear I agree with Cherif that deterrence really is not an issue here. And I think that there needs to be a change in legal culture before the ICC is going to be able to prosecute without conditions and with universal jurisdiction. I think we'll get there, but I don't think that it'll be tomorrow. There's nothing that I want to do to stop that happening. In fact, I want to encourage it.
I'm encouraged by your observation. I share your feeling that it's a desirable result. I share your doubts about deterrence. Not everyone will be deterred, but some people will surely be deterred. If the threat of trial and punishment would not be a deterrent, and we eliminated that in our national jurisdictions, we would soon see what chaos we have. So even though you're quite right that in many of the prevailing conflicts, deterrence might not have deterred, we don't know that. But in future conflicts, I think there will be some deterrence. I think there is an awareness then that doing what they used to do and get away with is not going to happen anymore. And if you, instead of that, just say they can never try you for that, instead of deterring, it encourages people to do the crime. And that's what we're trying to avoid, the feeling of immunity. So it requires a little more thinking. The complicated problems that you correctly raise, I would suggest leave it to be resolved as the problems arise. The judges will be able to cope with most of the problems. If not, they can always come back for amendments later. My thrust is, now, don't repudiate Nuremberg, because by failing to make the crime punishable, it seems to me, and the International Law Commission agreed with that, a repudiation of Nuremberg, which they were not ready to endorse. And so I hope that you will practice walking a little bit faster, or if you can't, at least you can induce your government or some other governments to do the same. Thank you.
Larry, let me, and as you're walking over to Larry, I just wanted to put one question out too, because I don't want us to leave without, we've kind of touched on this issue of the General Assembly playing a role, but we've not kind of delved into this. And certainly the General Assembly has had an opportunity in the past to deal with this issue of aggression, and if in fact it would have a 2/3 kind of vote on designating aggression. Is that not an appropriate or better approach? Now, Ben, I know that you're not a firm believer in the General Assembly's role, but I would just be curious about either of you on talking about the General Assembly's role as a kind of a trigger mechanism.
If the P5 really want, if their motive is really to have control of the process, then they're not going to be happy with the General Assembly, if that's the motive.
And my answer, I just wanted to, right here. I think, Stefan, that's what you were trying to explain. I just wanted to put that slide up, for people to look at in terms of the non-paper approach that is part and parcel of, I think, of what you were talking about. Well, two things. One, the General Assembly has already demonstrated a very critical role in this process because Resolution 3314 of 1974 has been a template from which so much has been developed and discussed in the working group. So we do have input from the General Assembly just in terms of how we're structuring this entire process. But secondly, I guess where I come down on it is that I don't have a particular difficulty with the General Assembly making the determination, that the political determination that an act of aggression has occurred, as long as the process that gets the issue before the General Assembly has first been initiated and launched within the Security Council. On basically the theory the Security Council does not want to make that decision, and yet is willing to have it determined by a larger body within the UN. That may sound implausible, but one can imagine any number of scenarios where, in fact, the political decision may be to kick it to the larger body.
Thank you, David. Larry?
So I'm even more worried than I was before I came to this panel about the issue of the independence of the judiciary. And and I mean, I think that there's been a real struggle, but a kind of success so far in trying to keep the ICC relatively independent of political influences. Now, whether we could disagree about exactly how far that's gone, but it sounds to me, especially with David's talk, as if, in his view, if we move to include aggression, then we're going to also necessarily undercut some of that independence for the judiciary. And I wonder whether you're willing to recognize that, and if you think that's, as I do, a bad thing.
Well, recognize that the Rome Statute already has linkages with the Security Council in it. No, and one can make a judgment call. You just drop the idea of including the crime of aggression altogether. I mean, there's got to be some give somewhere here. And you could sustain what the degree of independence that the court currently has, even though it has some linkages to the Security Council through Article 16, obviously, and we're seeing that play out right now, by the way.
That's the dilemma you've left us with, right? That if, that on your view, in order to include aggression at all, it means that we have to undercut the independence of the ICC, and I guess I find those two options not acceptable.
Well, that's fine, but of course, you know, there's always the purest approach to solving these problems, and then there's the more pragmatic.
David, Elizabeth, thank you. It was an excellent discussion, and thanks for the audience on this.
And thank you, Mark, also for moderating. We will recess for 15 minutes and reconvene at 3:45 sharp.